Why is moving out the biggest mistake you can make during a divorce? Leaving the marital home before your divorce is final can seriously damage your custody, financial, and property rights in New York. Under New York Domestic Relations Law Section 236(b), courts divide marital property based on fairness rather than automatically splitting everything equally. When you voluntarily move out, you may unintentionally shift important factors in your spouse's favor. Courts generally try to preserve the status quo during divorce proceedings. If you leave the home, you create a new living arrangement that a judge may be reluctant to change. Under DRL Section 234, a court can award exclusive occupancy of the marital residence to either spouse during the divorce. If your spouse has been living there alone for weeks or months, a judge may formalize that arrangement. Temporary orders often set the tone for the final outcome of a divorce case. If your spouse receives temporary exclusive occupancy or primary custody, reversing that decision later can be difficult. Filing at the New York County Supreme Court at 60 Center Street in Manhattan begins the formal court process. From that point forward, your living arrangements can become part of the court record. Child custody decisions in New York are based on the best interests of the child. A parent's daily involvement in a child's life is a significant factor in that analysis. When you move out, you typically reduce your day-to-day contact with your children. A judge may interpret that reduced contact as evidence that your spouse is the more involved parent. Courts are reluctant to disrupt established routines for children. If you begin visiting only on weekends or certain evenings, that pattern can become the default parenting schedule. Judges often formalize the arrangement that has already been working during the case. Your new residence will also be evaluated for suitability. Factors such as proximity to school, number of bedrooms, and overall stability matter. Under DRL Section 240, courts consider each parent's involvement in daily life when determining custody. Moving out can also create financial pressure. In Manhattan, maintaining two households can significantly strain both spouses' budgets. Even if you leave, you may still be responsible for mortgage payments, property taxes, utilities, and maintenance. The court can issue temporary maintenance orders under DRL Section 236(b) 5a. The court can also issue child-related financial orders under DRL Section 240. If you are paying for two residences, the court may scrutinize your finances when setting temporary support. If you are the lower-earning spouse and move out before securing support, you may face financial hardship. Moving out does not eliminate responsibility for joint debts. Credit cards, loans, and shared financial obligations remain in place regardless of who lives in the home. New York follows an equitable distribution model under DRL Section 236(b) 5. Equitable distribution means fair, not necessarily equal. The marital home is often the most valuable asset in a divorce. Moving out does not automatically forfeit your ownership interest in the property. However, the court may weigh who has been maintaining the home and who has primary custody of the children. If your spouse has been living in the home with the children for an extended period, a judge may decide that awarding the home to that spouse is more equitable. Another overlooked issue is access to financial records. Important documents such as tax returns, bank statements, and mortgage records are often kept in the marital home. If you leave without copies, you may need formal discovery to obtain them later. There are situations where living separately may be appropriate. If there is domestic violence or a credible threat of harm, safety must come first. New York law allows orders of protection that can grant exclusive occupancy to a victim. Emotional well-being is also a factor. Living under the same roof during a divorce can create ongoing conflict and stress. If separation is necessary, it is often wise to formalize the arrangement in writing before moving out. Under DRL Section 170(6) spouses who live separate and apart for at least 1 year pursuant to a properly executed separation agreement may use that ground for divorce. A separation agreement typically addresses custody, support, property use, and financial obligations. Legally, both spouses usually retain the right to live in the marital home until the divorce is finalized. However, your spouse may request exclusive occupancy under DRL Section 234. If granted, you may not be permitted to return. Abandonment is a fault-based ground for divorce under DRL Section 170(2). Although no-fault divorce under DRL Section 177 is more common today, abandonment claims can still influence contested cases. If you leave without legal guidance, your spouse may characterize your departure as abandonment. Before making any decision, consult a lawyer to understand how moving out may affect custody, property division, and support. An experienced attorney can help you evaluate the risks and protect your interests before you change your living arrangements. At Juan Luciano Divorce Lawyer, our law firm represents clients throughout Manhattan and New York City in custody, property division, and temporary support matters. Our attorney has practiced family law in New York City since 2005 and has been admitted to the New York Supreme Court Appellate Division 2nd Judicial Department since 2005. This law firm maintains offices in Midtown Manhattan and the Bronx to serve clients across the city. Every divorce decision carries consequences, and guidance from a knowledgeable lawyer and attorney can make a meaningful difference. Juan Luciano Divorce Lawyer is located at 347 Fifth Avenue, STE 1003, New York, New York, 10016, United States, and you can call 212-537-5859 to schedule a confidential consultation.